Welcome aboard, everyone. We're here today to start looking at the Security of Payment Act changes in Victoria particularly. And first of all, I suppose there's got to be a little bit of a disclaimer in the sense that we'll try and cover all the aspects today, but for a particular matter, you should get some independent advice and look at things carefully because, as usual, the devil is in the detail. So we want to look at the changes that happened in Victoria around about the 15th of April. The situation is before that, the Victorian Act, from an Australian perspective, fell behind what the other states were allowing for a contractor. Fundamentally, if we use the New South Wales as a benchmark, New South Wales let you claim a lot more things than the Victorians. The Victorian, previously to these changes, said that if you had a contested variation, fundamentally you couldn't claim it. And there are other restrictions on you claiming the situation. Those have now been released, and there's an expanded role for this to play. Looking at the Security of Payment Act as it's developed over the years, we've got to understand that from a contractor's perspective, this is a very important piece of litigation. And fundamentally, when my clients talk to me about having a contract, I say to them from the start, you should look at the contract and you should look at the claims that you're going to make under that contract as if you are going to push them all through SOPA, all through this Act. And it's important that you have a very complete and adequate payment claim, because if you don't get it right, you can upset your whole process. This gives you the opportunity to get a statement from the principal that defines what he will pay, what he won't pay, and why he won't pay it. And that's a very important step. Back in the bad old days, you simply got obfuscation and delay until a year after you'd finished the job. But now this Act comes in and says, no, the principal has to give you a payment schedule and reasons as to why he won't pay anything he's not paying, or else he'll have a claim will be accepted against him. So if we look on to the bigger picture for the minute, the idea is it's intended to support cash flow in the industry, and it means that you've got to comply with the procedures and make sure you perform according to the expectations of the Act. Now, the Act expects you to be on top of your matters and to have careful administration. So there's no point saying, well, I've had 400 variations and I lost track of them, because if you lose track of them, your claim will be a mess. The rejection and schedule of it will be easy, and any adjudication you go to is going to be confused. And realise that the general feeling with SOPA Acts claims is you only get one shot. You can have one shot and then it either succeeds and you get paid something on account, or else it doesn't and you end up paying the adjudicator's fee, which can be substantial. In a recent matter I was in, the adjudicator's fee came to $93,000. I didn't think it was reasonable, but it had to be paid. So it's an Act that tries to dispense judgment in a quick and easy way, but it's awkward along the way of that. It doesn't have the rationality and the sense of balance and the sense of judgment that you would get if you went to the Supreme Court. Of course, going to the Supreme Court will cost you a lot more and take a lot more time. So the situation is you've got to understand why they reformed it. The reform was to strengthen the payment protections and to remove restrictions. So there is an attitude that they've opened the Act up, and you should be responsive to that. That is, you should look at all your contract procedures and make sure that they're clear, comprehensive, and kept current. With good administration, you've got a chance to make sure that any claim you make is well documented and effectively hard to displace. But if you confuse it and involve in long email chains of confusing discussion about claims, you'll end up with a bit of a mess. So the other aspect that the Victorian regime has taken a step forward is it's addressed unfair contractual practices. So they're saying, as we'll see when we look at it, that the circumstance is that if you try and put in some unfair clauses, the Act may in fact invalidate them. So that's an important development, and it's an important development if you're, for instance, facing unfair time bars. So the time bar is that if you don't claim within 24 hours, then you lose your claim. That would be unfair, and this Act tries to restrain them in and make sure that they don't actually apply. So you should come out with an impression that the government has tried to clean up some aspects of the construction industry and make sure that the claims procedure is fair and reasonable. It doesn't remove all the risk of contracting, but it substantially reduces them. The other aspect is, as the advice when you're working on a project is, it's like when you're being chased by a bear with one of your mates. You don't have to run faster than the bear, you just have to run faster than your mate, and the bear will get him. And similarly on construction sites, if your documentation is in better order, if you're on top of your claims, then it's likely that your claims are getting better treatment and smoother progress than some more uncoordinated subcontractors. So the first aspect is you have to make sure that it applies. So it only applies to contracts to carry out construction work or supply related goods and services for construction work in Victoria. So again, if you put in a contract to supply stuff to over the border, then the situation is that you won't be able to claim it under this Act. You'll have to go to the New South Wales Act or the South Australian Act. Or if you're in international work, you'll have to do it under the equivalent legislation in Tasmania. You've got to make sure that it's the destination of the goods and services that's the controlling point. The situation is that you've got to be careful to make sure that if you're working on a domestic building contract, that is, somebody's building a house for a owner that's going to live in it, then the situation is that if you contract directly with that agent, usually in Victoria, you can't put a claim in against him. That's different in New South Wales, where you can put in a claim and some more restrictions and adjustments, but it's available. So it's important to say that you can't enter into a contract directly with the building owner, but you can in respect of a claim against the builder. So the other aspect is, if we look at the key legislation changes, run over a bit of a summary of those. One is that they've replaced the reference dates that we used to have to struggle through in the previous Act with a statutory month, the entitlement to make a payment claim. So it's simple and straightforward. And the extension of the final statutory payment claim from 3 months to 6 months. 3 months is pretty tight. In New South Wales, you get 12 months. In Victoria now, you get 6 months. So that means you've got to clean up your last claim and make sure that it's put in comprehensively and properly as quick as you can. The other aspect is, when planning for a claim under the Security of Payments Act, you want to go early, because then if you find that there's some significant deficiency in your claim, you'll probably have a little bit more time to try to give it another spin on the next month. That way you can fix it up, you can correct any errors, and therefore you can put a better claim forward. The situation is they've removed claimable variations and excluded amounts. They put in a maximum period of 20 business days for payment and release obligations. The statutory entitlement to claim back your performance security. So if you've had retentions or you put in a bank guarantee, you can get that back. And the situation of mandatory advance notice before having recourse to performance security. And in that means that at least you'll get a warning. It is beneficial in the sense that you might be able to warm your bank manager up to the fact that there's going to be a bit of a demand and seek to organise with him that it's not going to cause too much of an impact on your banking arrangements. But it does also give you a bit of a chance, if it is totally outrageous, to consider going to the court to get an injunction. The courts are very much against giving injunctions, and it's a hard bar to leap over, but at least the notice is a useful courtesy. There's new provisions dealing with unfair notice-based time bars, so that's a great benefit. That is that if there is a unfair notice provision, the circumstance is that you've got a chance to upset it and avoid it. But one has to remember as a contractor that it takes a fraction of the cost to comply with the time bar as it does to upset a time bar. So the circumstance is you should look at the time bars in the contract before you start work. You should map them out and make sure you comply with any of them. And you should comply in accordance with the contract as best you can. But a bad compliance is worth 100 times non-compliance. And you should make sure that you've got your best claim in before the time bar there. There's also restrictions on new reasons being introduced to an adjudication response, so that the principal is bound by the payment schedule reasons, which is a fair improvement in the legislation. And there's a 5-day opportunity to provide a payment schedule if one hasn't been provided before you go to adjudication. So they're all improvements, and some of them, like the claimable variations and excluded amounts exclusion, is very significant and will lead to a lot more claims in Victoria, a lot more claims being accepted. So that's important. And they put in there for a 22nd of December to the 10th of January from the calculation of business days. And effectively that means you can't ruin anyone's Christmas by putting a claim in shortly beforehand. So that's an aspect. They've modernised some of the service provisions, going to a more digital world. So those are aspects which are improvements. So fundamentally, if you look at this and we stop here and say, where have we got to? We've got to a situation where Parliament has loosened up this Act and has made this Act more attractive. And it's easier to get a claim up, and it's easier to get an adjudication of your claim, which is a lot better than arguing about a claim for 6 months, when you can have a pretty quick decision on the claim in 2 months. And oftentimes you're able to preserve the relationship with the other party by the fact of saying, well, look, we'll just go to an umpire. I'll put my claim in for $100,000. You've knocked it back. Okay, let's go and get an umpire to come in and have a look at it, and we'll accept his decision. And you try and sell it as a cooperative way of resolving project difficulties on the go. And the situation is getting back to working together to get the project done and the payments made. So with payments claim, the situation is you make it on a monthly. The situation with reference dates caused many claims to be dislodged, but that won't now affect. And the circumstance is that the contract can permit an earlier claim date, but that can't postpone the statutory entitlement to a later date. It can't say, well, you can't claim this for 3 months. You are entitled every month to make a claim. You've got to be a little bit careful into how the Act applies. We've had a situation recently where somebody finished some work on the say 16th of the month, and they put a claim in on the 17th, but they weren't really entitled to do it, we thought, reading the Act, until the end of the month. And then the respondent to that gave a payment schedule before the month ended. So it looked like we had an early claim, which was to be taken as being made at the end of the month, with a reply that had come in before the claim was really effective. So it's an issue then that you've got to think your way through the provisions of the Act and make sure that your payment claim is right, the payment schedule is correct, and that the process can work smoothly. So the situation is that now it arises under the Act. You have a right under the Act to make the claim, rather than depending on a contractual or statutory reference date, which was a worry. So you've got a monthly entitlement to payment claims, and on and from the last day of the first month in which construction work's carried out or related goods and services are supplied. So that's when you think. So the last day of the month is when you should put your claim in. So on every project, you should be fronting up with a claim that's ready to go on the last day. So the situation is that you can provide earlier, but that you can't make it longer. And the circumstance is only one payment claim can be served in respect of each month. So if you serve one, you serve it early, it's taken to be effective on the last day, but you can only have one. It's very important to stop what is otherwise sloppy accounting practices, because a lot of businesses whistle out invoices and chase ups for payment and everything willy-nilly. But if any of them approach a payment claim and you've made it earlier, and then you make another one, and the second one is the real one, it's the well-documented and detailed claim, effectively it mightn't have any bite, because it might be excluded because you've made an informal payment claim earlier. So you've got to make sure that your accounting staff are pretty well briefed on the Security of Payments Act, because it's their job probably to put out much of the payment claims. They should make sure they satisfy the requirements of the Act, and they make sure that they don't do it too enthusiastically, because if they issue more than one, you disqualify yourself. Well, there's a talking about reference dates, but it's been removed. It's a situation where it's a benefit to have it gone, because it required a bit of complex understanding of the Act and the legislation to work out whether or not, particularly if the contract was terminated, whether or not you had another termination date to put your last claim in. But the situation is that that's now behind us, so we've had some benefits. You got special rules for December, so don't put a claim in on the 23rd of December and then sort of expect that you're going to get a response within a certain number of time. The situation is that those days won't count as business days, and accordingly it extends the time that your opponent has the opportunity to respond. Not a bad solution. The extension of the final claim period. The situation is previously it had to be served within 3 months after the practical completion of all construction work, or 3 months after the all related goods and services were provided. But the situation is that that has been extended now. The corresponding statutory period is 6 months, and any later final date permitted by the construction contract. So the construction contract can extend that date, but it generally can't shorten it. The situation is runs from the practical completion of the overall construction work or completion of the overall supply, not separately from the date of each individual item claim. So that means that if you were constructing dog kennels and you constructed them one after another, then it would run from the 6 months after the last dog kennel was completed. It wouldn't be a 6 months only on that dog kennel. It would allow you to go back over the whole contract, and it might allow you to claim for the extra cost of painting the dog kennels that went back for a year or two before the last one was completed. So it's important to make sure that you're watching these periods and you've got a claim in for all aspects. The situation is what must be included in a payment claim. So it could include one or more progress amounts. You can claim for 3 months or 6 months if it hasn't been paid. Any related goods and services. So you want to be careful to make sure that if you've provided some extra service, it's a variation of some sort, and you have an entitlement for payment, then you might put it in. Amounts included in earlier payments, sketch claims that haven't been paid. They should be rolled up and put in. Variations are now able to be claimed, and any other amounts recoverable as a progress claim under your contract, looking at your contract to see what can be claimed, and under the Act. And then the situation is that a payment claim before the earliest permissible claim date is not necessarily invalid. The situation is it may be taken to have been served on the earliest date that it could have been served. So there's a bit of a saving for the contractor who's jumped the gun. The claim will take effect effectively from the last day of the month. So the situation is that that's broadly what you've got to include in a payment claim. But of course, you should also look at the content to the payment claim. That's the sort of timing of it. But what about the content? You must identify services with which the claim relates, or that you can identify the work you're claiming for. Now, while that seems simple when you say it fast, it needs some consideration when you're preparing your claim. The idea is that if you claim for concrete work in the last 3 months, that might not pass the bar. That is that it's not identified as what concrete work there was. So it's important that one turns one's mind to it and says, well, how do I define the work that I'm claiming for? So it might be in that case that you indicate the areas of concrete that were done within the last 3 months, but you actually say it's bay 4, 5 and 6 as marked on plan X, Y and Z, so that it's specified so you know exactly what it is. And you've got to look ahead in how you're indicating what you're claiming for to an adjudication, because if an adjudicator's got to value the concrete work you've done in the last 3 months, you've got to give him as much an assistance as you can. So if you don't specify it in the claim, you may find it pretty awkward to try and then identify what it was you're claiming for. It goes back to when you set the contract up. We've got to think through what sort of claims are going to be made under it. And you want to have the items identified with their value broken down in some sort of bill of costs, so that you can say, well, I want to claim for the concrete, I want to claim for the underlay of the concrete, and I want to claim for the layer of bloody anti-evaporation I put on top of it, in which case one should say, right, well, how are we going to do the concrete? The concrete's going to be done in 6 lots. Okay, well, then we sort of, well, why don't we price it out in 6 lots? Say lot 1, lot 2, lot 3, and lot 4. And when you put your progress claim in, what are you claiming? You're claiming for the excavation for slab 4, and you're claiming for the concrete for slab 3. And everyone understands your claim, and it can be a lot better easily adjudicated on. And it also encourages and motivates the recipient of the claim to actually address the claim and either say why he is happy to pay it or why he's not. So that's there. The other aspect is you should look at the contract. And if the contract says, well, you're only allowed to claim if your concrete's, cured for more than 7 days or has some other restriction in it, must satisfy the requirements of, code number 457, then it's worth turning your mind to the fact of satisfying those minor obligations of getting an engineer to certify that it does accord with the code and making sure that is presented to the principal in a way that will back up your payment claim. So it's a matter of carefully addressing these issues and carefully specifying when and how you're entitled to claim and making sure it's a no-brainer, that you're not putting in stuff that requires claims even after they've gone through to the Supreme Court. That is, they've gone to a stage where they've been adjudicated, money's been awarded, everyone's gone to court, paid big fees and lawyers' fees, and then the court said, well, you haven't identified your construction work. You've just put in a mess of stuff which doesn't work. You've got to be careful that you're on top of the game, not behind it. So we then look at payment schedules. Now, of course, payment schedules most particularly relate to principals, but they also relate to contractors. And every contractor fundamentally has subcontractors. And when you've got a subcontractor, you've got to make sure, as he's usually doing construction work, that you've responded within the time that is appropriate and that you put down all reasons, and particularly that the reasons relate to the contractual liability to pay. There's no point in putting down a reason to say he was hopeless and I didn't trust him and fundamentally he never showed enough skill to deal with the thing. That won't cut much ice with an adjudicator. You've got to say, right, Condition 7 said that he should have had it signed off, the excavation of this slab signed off by the engineer before he poured the concrete. He should have said that the concrete shouldn't have been laid unless the engineer had given us a certification about the reinforcement. The situation is that must be specified. So again, when you've got reasons as to why not to pay, the situation is you should specify them and relate them to the contract and his obligations to deal with it. The other aspect is you've got to say how much you propose to pay. Now, that might be zero or it might be part of the amount claimed, but you've got to state it fairly clearly and unequivocally. And you've got to include all the reasons, and you've got to get the reasons out within the recognised time. And in that, it is again a situation where the time limits are crucial. If you get a payment schedule back 2 days late, it's worth nothing. So the situation is 2 days early, it's fine. 2 days late, it's nothing. You've got to realise that the time is an essential, mandatory element of the whole process. And having got it back within that time, you're fundamentally going to be restricted to the reasons you raise. Firstly, as a matter of common sense, because the adjudicator is going to regard later reasons as more sort of, drummed up reasons, as less credible reasons than something that you put down in there. The other aspect, though, is you must get some reasons into the process if you don't intend to pay. And therefore, it's important that you have a standard set of reasons that you go through and articulate. You tick them in, the ones that apply and the ones that don't, and then you've got a basis for doing your schedule. But if you don't have the preparation done for a payment schedule, it's very likely you'll either mess it up or else put in an inferior schedule. So should, as a principal or as a contractor dealing with subcontractors, make sure that you've got a pro forma that focuses on getting a proper payment schedule done. The respondent can't introduce new reasons in an adjudication response which are not included in the payment schedule. That's only fair in lots of ways, and it addresses the situation that you've got to put up or pay. So the circumstance is that that's there. The consequences of failing to provide a payment schedule. You've got to be careful about this because you might be running a job and you might have agreed on a couple of likely lads that they should be on a, ABN, and they're a bit of a contractor, so that's okay. And they work hard sometimes and they do good work sometimes. And if they put in a claim, as more and more people are doing, under the Act, then you'll have to make sure that your payment schedule goes out in the right time, in the right form, with the right reason. Because if you fail to put the payment schedule out, then the claimant can recover the unpaid amount as a statutory debt through the procedures in the Act. So he may apply for adjudication and continue and give you another chance to put in a schedule, but alternatively he may go straight to court. And fundamentally, the theory is in court that if you haven't put in your payment schedule, he will get paid, and as quickly as possible. The practicality of going to court, though, is that courts invariably require a higher sense of justice, a higher sense of accuracy, and delays occur. So even for a contractor who has not received a payment schedule, it's a decision worth contemplation as to whether or not you go straight to court or you go back, give the notice, and then go to adjudication, because adjudication is quicker. Additionally, adjudication has the advantage for a claimant that you have to pay the adjudicator's fee perhaps, but you don't have to pay the costs, the legal costs or technical costs of the other party. And sometimes if you go to court and you lose, generally you pay the costs, and that's a substantial issue. It's important to get it right and do it. So the situation is that the choice for the claimant, if he doesn't receive a schedule, is go straight to court and try and collect his money straight off. Alternatively, he can apply, give a notice of intention to apply for adjudication and go to adjudication. That will be simpler in lots of ways, and also usually probably just as fast. So you then get sort of the second chance payment schedule. So person's made a claim against you, you've forgotten to put your payment schedule in. He says he wants to go to adjudication, so he gives you a notice to apply for adjudication, and you have to do something. You only get a limited time, and the situation is you only have 5 business days. Now, 5 business days is not a long time. You've got to put a day at the end for service to making sure it's served properly. You got a day to sort of understand what the claim is, and you've only got 3 days to really answer it, and you've got other jobs to do during that time. So the situation is it means you've got to get your skates on very quickly, having got that notice, and you've got to get a claim in. Recently in Victoria, we've had a claim that's come in on the Monday, and we chopped out the payment schedule by the Friday. That's the only way to do it. You can't leave it for any length of time, and you've got to get it in early in order that it complies with that. So it's not something that you should encourage as a respondent to a payment claim, you should get your payment schedule in the first go, because you get more time to do it and a better job is done. So adjudication, it's important to sort of understand the adjudication process. Firstly, it's appointed in a reasonably neutral and non-biased fashion. So there's a reasonable acceptance in the industry of the quality of adjudicators. Fundamentally, most appointed have been fairly sort of straight down the line, not favouring any person, and generally they have presented some reasons as to why they've decided what they have. The situation is you don't always agree with them, but on the other hand, it's clarity, it's certainty to get a decision whereby you can say, well, at least someone independent has looked at this and he's come to this view, and that's a little bit better than having to talk to the other side who's intransigent and not going anywhere. So broadly, it's meant to be a rapid adjudication process. It's usually pretty quickly, but people jump into it, and usually 10 days will see much of the work done and finished. And the circumstance is an adjudicator will then thump out his decision, and provided you pay his fee, you get to look at it. So it's reasonably straightforward and reasonably effective. And for the claimant, it's much better than going to court. One aspect is you've got to understand the approach the courts take to adjudication determinations. And on the one hand, they're very tough if the adjudicator fouls up things badly. If he makes a big mistake, he doesn't consider arguments, he doesn't allow people to make the submissions they should be allowed to do, and he, in his process, he commits a mistake, which means that he hasn't done the duty, the act imposed on him. And they will upset it. But on the other hand, they have said that if he makes a mistake about the contract or about the facts, they won't really upset. He's got an opportunity to make mistakes about the law and facts, but he hasn't got an opportunity to make mistakes about the process, about the things that he's to consider and the fairness of the project, of the process. So they've given him quite a lot of liberty to come to decisions that appear to him to be fair and reasonable, and yet they will maintain a supervision of him to make sure that he's following the process that's set out in the Act. As to the changes, there's longer periods for the adjudicator to determine applications, give it a little bit more extra time. Restrictions on raising new reasons in adjudication response, which is useful and helpful, we've talked about. And the abolition of review adjudication applications, that was seen to be a procedure. It had some advantages, but it wasn't very broad. There wasn't a great deal of review ambit that you could do. And the situation is that there are procedural changes to improve efficiency and reduce unnecessary procedural disputes. So the circumstance is, again, Parliament's tried to make this process better, make this process a little bit more slicker and efficient, and it's something that should encourage you to engage in it, to be interested in it and making sure you do it. Again, you've got to look at your contracting philosophy and you've got to set yourself up for it long before you make a claim. But the situation is that lots of times in the past, people would let a dispute over something, dispute over the access to the site, dispute over the equipment to be provided, dispute over the facilities to be provided, and they let that run for a long time. It shouldn't be. You should raise your issues early. You should raise them when they're limited and they're small, but they're continuing, and then put them through the Act and encourage the other side to agree the umpire's decision, because it removes disputes early and it gives you a very good opportunity to negotiate. There's really no point in trying to negotiate where there's no pressure on the other side as to getting a resolution. So the idea is that you should put it up and say to the other side, look, we're happy to negotiate and get a reasonable solution out of this for everyone. And there's probably, 1 or 2 months during which everyone exchanges information along the line and we can resolve it. And even where it's gone to an adjudicator, and the adjudicator is thinking about it and working out his decision, there's still an opportunity to agree it, sign an agreement that settles it, and move on with your life. And it's better because sometimes a claim that you think is wonderful might be dislodged by the adjudicator. He might get the idea that, no, it's not reasonable, it's included in the contract. And the circumstance, then you might get nothing as a claimant. Alternatively, you could get the whole lot. But oftentimes, if you're able to settle it for a reasonable figure, it's more certainty, more money in the bank earlier, and a better result all round. So we've talked about excluded amount and claimable variations, which are a particular feature of the Victorian regime. And the circumstance is, I think they're a concept that is the industry's well rid of, because it was preventing lots of sensible discussions from being articulated and adjudicated on by somebody who was independent. And that's an assistance to everyone in the construction of projects. And the fact that you had to have practical agreement to everything but one item of it before you could seriously run it was a great burden. And the situation is the availability of adjudication removes the incentive for people to run silly arguments, because if you run a silly argument, then it's going to be resolved within a couple of months. So if you want to run a silly argument, you can, but it'll be pretty quickly told to be nonsense. Whereas when we were restricted to going to court, you had to wait 2 years before you went to court and to get a judgment, and you could be appealed. The situation was it attracted silly arguments, and these amendments are a great benefit. So the benefit of getting rid of those excluded amount and claimable variation concepts significantly improves the whole rigmarole, improves everybody's attitude, and improves its cooperation with the you get unfair notice-based time bars, and it says a contractual provision that requires a party to give notice and within a specified period and provides a party to do so may result in the loss of entitlement, right? Does not abolish notice-based time bars, but it allows certain time bars to be determined as unfair. So the situation is they're determined to be unfair, then the circumstance is that they won't apply. But the contractual notice provisions remain important and should continue to be complied with. As we said at the start, the cost of complying with a contractual notice is very small compared to the consequences of losing your whole claim. And you've got to be on your toes. So say, for instance, you're a contractor and you're digging your way through somebody's excavation, you hit a bit of rock which shouldn't have been there. You've got to notify that properly the same day. You don't wait, you don't mess around, you notify quickly. And people will say, well, the contract says you've got to notify as well the cost of it and the delay that it causes. Well, that's good. Well, give the best notice you can on the day. That is, if you can't judge the costs accurately, if you haven't got your favourite QS around to give you a delicately calculated conclusion, then you should still whack in the best cost estimate you can. And probably the sensible thing is to make it a bit more generous than it need be in order to give yourself some cover if you haven't allowed for everything. But you should get that notice in the same day. It's got to go off quickly. So you've got to comply if you want your money. So the situation is as well is that not all of time bar will be covered by it, and not all of them will be covered if you've got to go to court. So compliance is hugely important. There's more sort of claims affected by time bars than you've had hot breakfast. You've got to get them in, and you've got to make sure that you comply with it. The situation is you've got to decide what's unfair. Not every requirement will be unfair, but it was not reasonably possible. That is, if people sort of ask you to produce a fully completed, certified QS estimate together with the programmer's estimate of its delay, together with a description of the work required, together with sort of a schedule of the manpower and expenses, and they say you've got to do that in 12 hours, then it's not going to be accepted. It's going to be silly. And it would have been unreasonably onerous. That is, the circumstance is that you look at whether it was a sensible provision. The provision particularly say that you notify if you hit hard rock is sensible. It's notified that you've got to hit it within sort of 28, 48 hours. That might be okay that you uncovered it. But to estimate its extent and the extent of the cost involved and the delay involved might not be sensible to be estimated within 48 hours. And a lot of the time bars are unusually and unreasonably harsh, and the circumstance is that they will be attracted to a lot of this as well. You have to be careful of these days the Unfair Contracts Act that the Commonwealth has introduced. It's a very valuable act for contractors because provided you comply with the usual requirements, it says that if there's an unfair provision, it'll be knocked out if the court agrees with you, but also that those seeking to enforce it attract substantial penalty. So it's a two-edged sword. And again, in your subcontracts, you want them to be firm but fair. That is, you've got to have some discipline in the ranks. You've got to specify what you need, but you've also got to make it reasonably fair. Now, the situation is who decides it's unfair? Well, it could be any number of a team of likely lads, an adjudicator, a court, arbitrator, an appointed expert. You could always appoint an expert and say, look, these time-based bars are unfair and should be adjusted. It'll otherwise, if it is unfair, have no effect in relation to a particular entitlement. So the situation is that it will be disregarded. So they provide a safeguard, but they don't remove the need for proper contract administration. Can't stress that enough. Make sure you comply. The usual method of compliance is that one intelligent person in your payments section can save you a lot of grief and a lot of bad vibes. So in terms of time bars, issue notices promptly, comply with contractual notifications. When people say we want the cost, we want the time, we want this, and we want the extra, and we want the reasons for it, give them as best you can and pump them out within the time. And maintain accurate project records. Again, if you're hitting into a latent condition in an excavation contract, that latent condition might go on for 3 months. If you decide to sort of have some records after 2.5 months, you're not going to have records that'll prove much. You've got to do it on the time. people must get to the stage where there is at least a weekly report on matters that have impacted them, on variations, on time extensions, on other impacts that have affected them, in order that somebody can manage these time bars and the notification requirements. The other thing to remember in terms of construction contracts is that for the value of the contract, there is amazingly little reporting to the principal, to the person who's got to pay it. If you send a parcel from Melbourne to Sydney, the situation is the parcel person who charges you probably $60 to do the job gives you a blow-by-blow description as it changes hands and finds its way up the highway. But that's for $60 for a contract claim of $60,000. You're lucky to get more than a one-page invoice. So we're well behind in this area, and you should realise that when push comes to shove, there is a big demand for accurate information to specify the impact of things and the justification for costs. The other aspect that's important to realise, and there's been a recent case on it, which is performance security, and the circumstance is that the courts have started to develop a bit of a distinction between a performance security, that is, you put up a bank guarantee to secure your performance. If your performance is regarded as terrible, the courts are a little bit liberal in letting someone cash that. But recently there's been a case where somebody had to put up security in order to ensure the condition of pre-ordered goods. So it ordered goods that would have to be eventually included into the construction, and that security was provided again by way of bank guarantees. And the court said, well, that's not really allowed under the Act. The situation is if he's provided the goods and you've accepted them, then you should pay for them. And under the Act, that security was released back to the contractor, but the performance security was one which is seen to have a different nature and was therefore liable to be called up. So the situation is that it's a important aspect to make, and it's important if you're providing bank guarantees wherever possible to negotiate a reasonable situation in respect to them. On the one hand, if you provide a performance guarantee, a bank guarantee, you could imagine that anyone should be able to call on that if you foul up and you don't do your job. We understand that. But it shouldn't really be callable as a whim. It should be on a situation where there's a sensible sort of inquiry into the merits of it. That is, the person that wants to call it says, I'm calling it for a particular purpose, and this is the value of that purpose, and this is what I want to call on it. And there's an opportunity for that to be deliberated on by some independent if it isn't agreed. That's not the position at the moment, but to the extent that you can negotiate it, you should look to negotiate it. The other aspect, of course, is the relevant provisions that attach to the security will be very important. And the circumstance is that a situation is that you should be watching those words very carefully and making sure you understand the risk and that you're not overexposed. And the performance security have got specific statutory requirements that differ from ordinary payment claims. And you've got to be careful that you're satisfying those when you put your claim in to do it. But it's an important improvement that the Act is brought in to allow you an easy way of getting your performance security back. Otherwise, the position has been that people have been chasing their bank guarantees for years after they were due to be returned. So the situation, if you're on the other side of somebody wanting their performance, their bank guarantees back, then you've got to put in a performance security schedule. You've got to identify the performance security claim. You've got to state the amount you propose to release. So you've got to either say zero or something, and you state all the reasons for withholding it. And you've got to be, again, accurate and comprehensive in that respect in order that you can get the benefit if it's taken further. So the situation is, again, you've got to have those reasons ahead of time, and you've got to have them made current if you've been pressing for the performance of those things to which they relate. So if you're worried that the fellow hasn't, say, for instance, cleaned up the site, then you want 2 or 3 or 4 letters sent to him regularly saying clean up, clean up, clean up. So it's when you go to adjudication, you've got the evidence already there of what's gone on. The situation is that you've got some issues with the half of the bank guarantee to be released at practical completion, and the situation is that somebody's chased up his bank guarantee, and this is where he'll expect some proper answers as to why he can't get it and on what reason it's retained. So if you've got a series of sort of messy defects to fix, then what you've got to do is to make sure that you detail those and not just in a short email. You want to have an official defects notification clause so as that he gets a clear entitlement of a clear notice of the entitlement to retain them. So recourse to it, that's all. New requirement before you can pull up a guarantee. You've got to give a notice, you've got to specify it, and you've got to wait at least 5 business days before you do it. So again, you don't want to overstep those requirements. They must be there and present in your head when you decide to call that on. The other aspect is electronic service. It's been a very interesting case under the West Australian SOPA Act, and there the Court of Appeal in New South Wales had to adjudicate on a West Australian dispute. The 2 companies were based in New South Wales, but the work had been done in WA. And there it was a situation that if you wished to have a particular advantage, what you had to do was to serve the submissions and the backup papers on the regulatory authority, so they're registered, and then you had to, within 1 day, serve the submissions and the backup documents on the other party within 24 hours. And it wasn't served because instead of sending a email with the document attached, it was too big for that. So they sent an email with a link, and the link wasn't opened by the other party for a couple of days. So the circumstance is the court decided, well, he hadn't been served if he hadn't opened it. And then the court had to decide, well, this 1 day limit, was it directory? Was it sort of to be aimed at most times and okay if you missed it by not too much? Or was it mandatory? And there the court came down very right wing and said, it's 24 hours. If it's a minute late, the president of the appeal court said, if it's a minute late, doesn't count. So it's important. And it was a concern that 1, tight timetables, and 2, electronic service. Because these days, it's very hard to serve people other than electronically. The Act goes some distance to it, but it doesn't go all the way. And you've got to be very careful when you've got tight timetables of service that your service is fully effective. And it takes you quite some time to think your way through an unequivocal service that will stand up if it's challenged. The transitional arrangements, and some apply, some don't apply. So you've got to look at those things as you go through it. There's practical steps, which we've broadly covered in the situation that you've got to get your systems up at the time you sign the contract or before. You can't try and do them on the run when things happen during the contract. You've got to improve your reporting systems, and you've got to improve your communication system so you're able to better present to any adjudicator what's happened. One of the problems is that if you get lots of disjointed emails, it's pretty impossible to tell what's happening. The old idea of having a form or a letter that explains exactly what's happening, confirms it, and then makes clear what you're complaining about is a much more superior product. Key takeaways: you should use the Act early and often. We've covered most of the aspects here. Mainly, the problems arise from admin failures, things that could be cured. So it's important to get your systems looked at, get the systems online, and then follow them through. So I think we've got the final thought is the Act's a great benefit for the benefit of Victorians, and it shows the leadership for other states to pick up some of these notions. The control of time bars and the performance guarantees recovery is something that should be picked up by the other states. So I think I've covered most of the ideas that we want to cover today. I hope that I've galvanised you to get your systems smartened up, and I hope that you've been determined to insist on using the Act in order that the control of your cash flow and the control of your claims is much improved over what it could have been some time ago. We'd encourage you to enjoy the Act, enjoy the opportunity that it gives you to get a bit of justice in the industry and to follow a more efficient system. The issue to me seems that fair contracts develop efficiency, they promote efficiency, and they clarify matters. And we should all strive for them, both in the contracts that we have the opportunity to write, but also in the contracts that we resist and we respond to. So there's no point being backward in coming forward. And whenever you're presented with a contract, you've now got an increased standing to say, look, this nonsense is grossly unfair and impractical, shouldn't be in the contract, take it out. Let's get this project on a cooperative and sensible basis. All right, well then on that basis, I'll wind it up today and look forward to seeing you in one shape or another over the next little while, and all the best.